Yes.
Thought I'd return to the warranties in the EPS Sanctions Clause. So, if exposure is used in relation to the warranties in the same way as it's suggested that it's used in subclause C, then it looks like the warranties that are being given are extraordinarily wide, because they are not warranties that the conduct ordered is not prohibited or will not involve one of the listed parties in unlawfulness, but there is the risk that the appellants say, and which the judge concluded, is involved in the use of expose. And we say that just as it would be surprising without clear words if subclause C envisaged exposure to a risk without actually saying it, it would be as or more surprising if the warranty is extended to risks without saying it. So I think we have ended up dealing with the points I wanted to make on the whole of the EPS Sanctions Clause.
Yeah.
So having made that point as well. I was going to do Triton, Lark, Mamancache, and Ceto.
Yeah.
I might take them with a bit lighter touch than I was intending this morning. But if my learned friend who hasn't made his detailed submissions on these cases, if he addresses them in his response, then I would like an opportunity to come back to them in reply.
Well, no, I think you should make whatever submissions you like about the authorities that you say are relevant to the construction point.
Okay, thank you. Well, the first one is Triton Lark, the first decision, which is at tab 12 of the authorities.
Yeah.
And the clause being dealt with, this is a dispute about whether a ship owner was entitled to go to China from Hamburg via the Cape of Good Hope rather than Suez from the Gulf of Aden. The clause relied on is at page 250 of the authorities. And the judge summarises what it requires in his paragraph 36, which is on page 256, by saying the master or owners must form a reasonable judgment first that the vessel, her cargo or crew may be or likely to be exposed to acts of piracy. That's because the clause says may be or are likely to be exposed. And second, that such acts of piracy may be dangerous or are likely to be or to become dangerous, because that's also what the clause says. So this is a maybe or likely to be clause where express wording is used to cut into the charterer's key right. He addresses maybe or likely to be and says, this is in paragraph 38 of his judgment, that they must mean the same thing in this context, because otherwise it would be confusing. Now we could draw a comparison with the use of is prohibited or will expose to mean wildly different things, which we say they don't. And in paragraph 40 and 41, the judge just sets out what may be or likely to be requires. and says that it's a real likelihood, which is a serious possibility or serious risk. So there's an element of uncertainty permitted in the clause in the Triton Lark by the express words may be or likely to be exposed. Now, there was a dispute between us and the judge about whether in the second judgment in the Triton Lark anything had changed about the way that the judge construed expose. In his first judgment, he deals with it in paragraph 38. But the reason that the second judgment comes about, the second hearing, is that the parties tell him that actually it hadn't been common ground, or that there'd been a dispute between them as to the meaning of expose. And then on page 263, at paragraph 7, we see how the meaning of expose is considered there. The parties have addressed the dictionary definitions, and Mr. Nolan has pointed out that expose might be, you can be exposed to a risk, but you can be exposed to other things that are not risks. And so, and then Mr. Kenny, in response, did not challenge this, but noted that in this context, the phrase to be construed is exposed to war risk, so that he can get exposed to a risk in, because that's what the clause is about. And in paragraphs 9 to 15 of the second judgment, the judge goes about deciding exactly what the vessel or the owners need to be exposed to in that case. Ends up being essentially danger, which is taken from the wording of the clauses themselves, because this is about danger of piracy, but where the word danger is used in the clauses. So the judge revisits paragraph 38 of his first judgment, where he had put forward a definition of what the owners had to be exposed to, and recast it by reference to the express terms of the clause. So the judge's conclusion was that there wasn't really a shift between the two cases. And it's true that the judge, Mr. Here, said that his second judgment was consistent with the first judgment. But the fact is that by the end of the second judgment, he had concluded that the question he was posed with was whether in the reasonable judgment of the owners there was a real likelihood that the Gulf of Aden would, on accounts of acts of piracy, be dangerous to Triton Lark. And one sees from paragraph 9 to 15 that that is based on the specific words in con wartime in that case, and that it's that is the decider, and the use of maybe or likely to be is the decider when considering whether this is a clause which involves exposure to a risk, or whether it's a clause that involves exposure to something else that is not a risk. And we see a clause of the latter type in the Mamankache decision, which is also a decision of Mr. Justice Tier. But the judge based his construction of our clause on Triton Lark, but that was a maybe or likely to be clause, and the thing that the vessel had to be exposed to was danger, and our clause is different in both of those respects. So Mamankache is tab 17 of the authorities. This is a case, a dispute about whether an insurer was entitled to refuse to pay a claim by reason of US primary sanctions. I suspect it's the reason that my learned friend wants to separate payment cases from other cases. But we say that oughtn't make a difference, particularly in circumstances where our clause has a reasonable judgment component, which is what makes the clause workable, and that the context can't tell us what the thing is, or whether exposure to a risk is within the scope of the clause. That depends on looking at the wording of the clause, where we start from, and whether there are any words to get us to a risk being included.
Mr. Justice Tier does make the point, doesn't he, that there's many an insurer and reinsurer who would like a clause to say your accrued payment obligation only has to be performed if you decide that there isn't a risk of some adverse consequence.
Yes, and in fact, I mean, there's a broader point arising out of that, which is that, of course, every ship owner would like a clause which said, if you have any doubts whatsoever about whether you should do this, you don't have to do it. That doesn't mean they've got that clause, because
I think the difference between the two is that if they're right here, an alternative order falls to be given that they have to comply with. In this case, the only obligation a reinsurer has is to indemnify. It's purely monetary obligation. And if it's relieved from performing that in a business in which cash flow and the time value of money is everything, that would be a very considerable commercial advantage.
Yes, but we don't accept that there is a material difference between the Mamankache situation and ours. It might be that, I mean, undoubtedly the decisions are made in slightly different contexts, but the clause says what state of affairs has to be judged in both cases, and there's nothing on our clause to suggest that the owners have bought themselves a wider right to refuse to comply than the insurers in Mamankache, particularly when, just as in Mamankache, you might start from the proposition that, well, in our case, you start from the proposition that the right is a key right, and so you need clear words to cut into that right to have your orders performed. And there's nothing in Mamankache which suggests that any other consideration was necessary to construe the clause that's more persuasive than our key right starting point. So the clause, again, in Mamankache is on page 343 of the authorities. It's set out in the head note in the Lloyd's report. They don't have to pay any claim if it would expose that reinsurer to any sanction, prohibition or restriction, etc., etc. There's no reasonable judgments clause in that in that clause in Mamankache. So that's actually a harder case, you would have thought, and therefore a stronger authority for us, because the judge goes on to say that expose here requires there to be an unlawful conduct involved in the payment, and unless there is, then there's no exposure to sanctions. Without the comfort that it's only a reasonable judgment that has to be formed. Now, again, there's reference to dictionary definitions. The claimant's submission is that the clause requires the defendants to establish on the balance of probabilities that the payment...
Sorry, where are you reading from?
Oh, sorry. This is in paragraph 43.
Thank you.
Judge says that claimant submits that the clause requires the defendants to establish on the balance of probabilities that payment would put them in breach of the applicable sanctions and thus would lawfully expose them to sanction. And that's the submission that he goes on to accept. In paragraph 46, and of course this is the same judge who decided Triton Lark previously, where the wording was maybe or likely to be exposed to essentially danger. And in 46 he says one can be exposed to a sanction in the sense of being laid open to a sanction or left without protection from a sanction, or exposed to the risk of being sanctioned. The present clause does not refer in terms to being exposed to the risk of a sanction or prohibition. It refers to a payment which would expose the insurer to a sanction. And then in 47, I won't read it all out, but he explains that before a sanction can lawfully be applied, there must be conduct which is prohibited. And therefore, in the absence of expressed wording, clear wording indicating that all that's required is a risk, it's only unlawful conduct and not the risk of unlawful conduct, which is within the clause. I mean, we would say that even if our clause said the risk of sanctions, it would still be more in keeping with the Charter's key right to construe that as saying that the risk of sanctions means the risk of that sanctions might follow from an actual breach. But we don't need to go that far because our clause doesn't even say risk.
Our clause.
The clause in our case.
Yes.
The
Our clause says such risk.
Well, such risk is...
As I've indicated, looking at other cases on other clauses, speaking entirely personally, I don't find very helpful. This case, at the moment, Mamanoche, seems to me to be authority for the proposition that you can't say that the clause must mean exposed to risk when the word risk isn't used, which for my part I don't find particularly surprising.
Yes, my lord, but well, it's where clear words do not indicate that the exposure can be to a mere risk.
Well, there's no reference to risk. It's not a question of clear words. There's no reference to risk in the clause here, in this case. So, therefore, I find the exposition at 46, 47, 48, I'm bound to say with respect to Mr. Justice here, entirely unsurprising.
Yes, but our submission would be that in our case, that unsurprising analysis ought to apply as well, unless...
That's the question of the interpretation of our clause, which you dealt with before lunch.
Yes. Now, there is the CETO case. I mean, I'm conscious of what your lordship says.
Well, I'm very happy to carry on and see if we can find one that might be of assistance.
Well, CETO is a case that might be thought to be against me. So that one perhaps I can leave to see what what my learned friend makes of it.
Just give us the reference to it.
It's the authorities tab 26. The headline is that it would not be the safe basis for construing the clause in our case, which your lordship has that point, I think.
Well, because it's different wording.
Well, yes, it is different wording. I mean, that's an important point, in fact. There's no is prohibited limb in CETO. and also it has to be said, it is very unclear whether Mamankache was cited in that case because it's not mentioned and it appears not to have been, and there's no engagement with the reasoning in Mamankache. So such risk we've dealt with. So we've also looked elsewhere in the EPS Sanctions Clause itself, but it might follow nicely from Triton Law to look at some text elsewhere in our particular charter party. So if we go to Core Bundle tab 19, pages 224 to 225. Here we see other clauses that appear elsewhere in the Charter Party for the Catalan Sea. Just over halfway on page 224, there's a war risk insurance clause in Catalan Sea Charter Party as well. And then about 2/3 of the way down the page, it's a large block of text, but without highlighting, these can tend to look like word searches, but we're looking for a passage which, in the reasonable judgment of the master...
It's not diagonal across.
No, happily not.
Just above the second hole punch.
Well, mine are spiral bound, so I won't try and...
See, that was one of the great traditions of looking at documents in court. You could say it's just above or below the first or second hole punch. Computerization has completely blown that as a means of identification, which is a great sadness to me, but doubtless not to anybody else in court. Anyway, it's just above my second hole punch,
yes,
which in the reasonable judgment of the master and or the owners may be dangerous or are likely to be or to become dangerous.
Yes, and then just a little bit further down, there's may expose or is likely to expose.
Yeah.
Can I just ask you about the construction exercise we're engaged on? This is a BIMCO war clause drafted by a BIMCO draftsman in 2004. The EPS Sanctions Clause is a clause drafted by or on behalf of the Eastern Pacific Group at some other indeterminate point in time. I don't know the answer to this, but certainly they began their life and their selection of language in complete ignorance and independence of each other. Does that nonetheless inform their meaning in this context?
I'm not sure that's true. I mean, if the EPS Sanctions Clause was drafted later than this clause, then it must surely be the case. I mean, this is the submission I'm making anyway. That clause. Well, here is wording that is in circulation and well known, that is not conspicuously not used in the EPS Sanctions Clause. So unless it seemed a remote possibility, a very remote possibility, that the EPS Sanctions Clause was drafted in ignorance of this type of...
It's an argument that doesn't actually depend upon the presence of the BIMCO war clause in the Charter Party as such, but on the fact that it would form part of the background known to people in the maritime community.
Yes.
Okay.
Well, yes, and we would say its presence in the same charter party is all the more significant, because if you look at if you're the owner and you look at what your rights are to do and not do things in this charter party, you surely say, well, we've got a wider right under the War Risks Clause to do or not do things than we've got under the EPS Sanctions Clause, and that is indicated by the use of may expose or is likely to expose, and the things that exposure is to, in one case expressly danger. So the charter party needs to be construed as a whole, and it would be a very unsatisfactory situation to find ourselves construing the EPS Sanctions Clause to have conspicuously different wording, but in many ways the same construction as these very different clauses, which are from a different part of the charter party, but which also deal with this kind of, in a broad sense, this sort of force majeure situation where something has, a situation is being addressed. So we say that when one looks at those other clauses which expressly do a very different thing, one is bound, in my submission, to construe the EPS Sanctions Clause in the way that we suggest. I mean, perhaps I can just give you the reference for it. It's on page 229. There's a Gulf of Aden clause, which also says the vessel may be exposed to the risk of acts of piracy.
So does that take us to commercial purpose?
It does. It does. I was keen to let you ask any questions about.
So just
I sensed one might be.
I want to make sure I've got the takeaway from these clauses. So you say here are provisions in the Charter Party, one addressing war risks, one addressing piracy off the Gulf of Aden, which use language of expose or likely to be expose. And then the next step is?
Well, we'd be looking for clear words in the EPS Sanctions Clause to bring in a risk-based provision, to make it a risk-based provision. We don't have them. So that on its own, as long as what I say about such risk is accepted, that we don't have them, so that on its own is enough for our construction to win. But if one looks elsewhere in the same Charter Party and sees clauses that expressly do the thing, or a very similar thing, to what the...
And you say they expressly do it because of what the word dangerous?
Maybe or likely to be.
Maybe and dangerous.
And there's exposure to the risk of acts of piracy in the Gulf of Aden clause on page 229 of the bundle, of the core bundle. So it's not only the submission that if the parties wanted to achieve what the appellants suggest, they would have used the words, but that they did achieve that elsewhere by using different words.
So they incorporated standard form clauses that use different words.
Well, yes, but that's a mode of putting together the Charter Party, and very little can be, I think, taken from that. What we are left with is a composite Charter Party, which says, which has a mixture, contains a mixture of provisions that do extend to risks and provisions that don't.
But when you do have standard form provisions, the rules of interpretation are that they have the same meaning in all contexts generally. That's what people are always telling me when they're asking for Section 69. Legal
Yes.
Point of law.
Well, that's right. But if you have a clause which is in the same neighbourhood as those commonly known clauses with familiar wording, but which does not say, I mean, you could imagine negotiation between these parties. You know, do you think that's the clause that we are happy with? Well, does it say exposure to a risk? No, it doesn't. It's not like the piracy clauses. Do you think we can live with it in the piracy clauses? Yeah, we can live with it there, as long as we don't have it in the sanctions clause. And yet what the appellants want to do is persuade you that actually, despite the different wording, they all mean essentially the same thing. And I mean, we're going to come on to the commercial considerations, but that is really being driven by a submission that because sanctions is a serious business and because any owner would want to have the maximum possible protection from sanctions that they can get, their construction ought to be favoured despite the fact that the wording isn't clear. And that type of argument, which is behind their case, oughtn't prevail in my submission. And there is a bit of that submission is used in a bit of a sort of free-for-all, which leaves the wording behind and says, well, look, a prudent owner would want a clause which protected them against risks, but a prudent charterer would want a clause that doesn't give them any right to refuse orders. So those sort of one-sided considerations don't work in my submission. We cite an authority, the good luck. We don't need to go to that because I suspect this is common ground that the interests of both parties need to be considered. And we have a general point here that it's important not to be squeamish about the idea that the owners might not have obtained the clause that they would like to have. And so they might find themselves in a position where their appetite for risk is not matched by the clause that their brokers or their lawyers or whoever it was has obtained for them.
But that's true in any dispute of contract construction.
Yes.
As a possibility.
Yes.
The court doesn't speculate.
Well, yes, but the submission that I say is essentially being made is that we would have obtained for ourselves the maximum possible protection, or the protection that a prudent owner would want to have. But it ignores, A, the possibility that they didn't get that protection.
The judge doesn't say anything about that.
No.
The judge doesn't approach this on the basis of what a prudent owner would have wanted.
No, that's right.
And this is your appeal against the judge's judgment.
Yes, but
you're saying this is what they got. And what that means on the conventional applicable principles of construction is all they get. And if that's not good enough for them, that's just how it is.
And it's important. The fact that they haven't obtained the clause that they might have wanted in an ideal world doesn't mean that they have to comply with the orders as a matter of fact. If they find themselves contractually obliged to do something that they don't actually, looking back, have the appetite for, that is a situation that, as I say, we should not be squeamish about, because
they could repudiate the contract.
Yes.
Well,
yes, I mean, that's the situation that they found themselves in. And that position should not drive the construction of the clause, which depends on ordinary contractual principle. So the other, I think there's only one other real commercial point, which is this suggestion that these decisions have got to be made quickly, and therefore we should construe exposed to sanctions, exposed to a risk of sanctions. The need for speed, to the extent that it exists, because look, in this case, there were 2 weeks went by while the situation was reached a resolution. But that's why the need to be sensitive to the need for speed is in the reasonable judgment component of the clause. It shouldn't affect what the clause is saying the judgment needs to be that you're exposed to. That, in my submission, is putting a square peg in a round hole. The reasonable judgment component of the clause is the total answer to, well, these clauses have got to be workable in the real world, they're going to be making these decisions quickly. Well, they have to make a reasonable judgment.
But if at the end of whatever reasonable period it is, the answer is we don't have enough information to reach a view, you say, well, that's just tough.
Yes, you haven't put yourself in a position to make the judgment that activates the clause, and that may be because you've agreed a clause that you shouldn't have agreed, or that you haven't got the infrastructure in terms of sanctions screening.
It's got nothing to do with whether you've agreed a clause you shouldn't have agreed. We're talking about reasonable judgment. You're now accepting the contract as it is, and you've got to exercise reasonable judgment in the time period. So what matters is the subject matter of the reasonable judgment.
Yes. My submission is just that if you find yourself in a position where, as Lord Justice Foxton says, you don't know, you're not in a position to reach the judgment that the clause requires for it to be activated.
If you don't know something, you have to make a judgment without knowing it.
If you need to make a judgment in circumstances where there are things you don't know, then that's true. Yes.
And that's always the case. Every decision maker doesn't know everything.
No, absolutely.
So every decision maker has to make a decision based on what they know and what they don't.
Yes, there will be things they know are the case. There will be things that they know are not the case. And in the middle, there may be a huge range of things that they may infer, may not be sure about. That's what makes these decisions ultimately the decision which the judge had to make as to whether they made a reasonable judgment. That's what makes them so fact-sensitive. Because...
Sorry, I was interrupting you because you seem to suggest that if there was information you didn't have, you wouldn't come to a reasonable judgment. That can't be right. You come to a reasonable judgment on the information you have, and if there's something you don't know, well, you don't know. And you have to factor that in to your reasonable judgment.
Yes, your judgment might be reasonable,
from reaching,
even though you didn't know everything.
Yeah, it doesn't prevent you from reaching a reasonable judgment.
I fear yet another judicial citation of Donald Rumsfeld is heading our way.
I hope not.
Right. So I think the only other item on my construction list is AI, and I wasn't proposing to say.
Oh, I'm sorry. I
much
should have said
about
I
it.
didn't. I meant to say I wasn't relying on that paragraph. Skeleton. I should have said that.
So before you move off construction, I take you back to the question my Lord Justice Foxton asked you earlier about the second half of C. And the premise is that the first half of C is dealing with voyage operations, and then the second half is dealing with matters that arise during the voyage. So if in the course of a voyage, what this is saying is if such risks arise in relation to a voyage that's you're already performing, which must mean, mustn't it, in the event that the risk arises of sanctions, being subject to sanctions.
Well, I think that might be where we part company, because what it's referring back to is prohibitive.
Okay,
So,
well, let's assume it's both then.
okay,
But
it's
the
referring
point
to,
remains the same. The question is, how do you avoid the word risks then? What's the word risks in that context? What does it mean?
Well, that's I've in my skeleton. I have yes. In my skeleton at paragraph 18, I had an attempt at paraphrasing, and the way I put it was, in the event that those conditions arise in relation to a voyage the vessel is performing, and that's all that's meant, rather than being a phrase that transforms everything else in A, B, and C. It simply refers back to both is prohibited and will expose, and says, in the event that those conditions arise, whatever they may be, in relation to a voyage the vessel is performing. But perhaps finally, we do say that even if this clause had used the word risk, and so I guess by extension, even if the words such risk have do have a meaning, then if one is starting from the proposition that the charters have a key right that only gets cut away where it's clear that it has been, then the furthest you need to go is to say that that risk is a reference to the risk that you might be sanctioned if you do something unlawful, or if one of the listed entities is involved in unlawful conduct, or would be involved in unlawful conduct. That's as far as you need to go, even if the words such risk have some relevance that's not just in the event that the conditions that have previously been set out have been satisfied.
So does that deal with construction?
That is construction. So, turning to owner's appeal, the overview here is, well, sort of at the outset, if we win on construction, then they lose, because they didn't make the judgment we say they had to make. I'm going to start by looking at the test and how the court should approach the appeal, but that appears to be, to an extent, common ground. Then say something about Vineshprom Bank and Vitasco.
I know it's never the easiest submission.
Yes, well, I was going to say with some trepidation.
You can say exactly what you like. I no longer have the ability to say
no,
what that term means.
It's a document that's out there, and yes. And finally, the owner's substantive decision and the view of it taken by the judge. I mean, this is a point that I might come back to, but there is a flavour of a retrial as we go through part of the evidence that the judge had in front of him, but it is necessary to show why there's more to it than my learned friend suggested this morning. Now, my learned friend has to show that the judge was compelled to take a different view. Nothing else will do. And we're going to look at a couple of cases in which different judges assessed different evidence in different ways and reached their own conclusions about that evidence. And that's just what the judge did in this case. It might be possible to assess or to have assessed all of the evidence in a slightly different way. That's not enough. And what I'm going to show is that the evidence was just as he said, but even if it wasn't quite as he said, on no basis in my submission can it be said that he was not entitled to come to the view, to come to the conclusion he reached on the reasonable judgment.
I'm not sure there's too much between you on that, because Mr. Vinyl puts his case fair and square on perversity. So there's no, I don't think there's a dispute that the ordinary rules apply when seeking to appeal a judge's evaluation of evidence.
No, there may be, I'm going to look at this in a moment, there may be an important difference between us on the proper basis for the objective judgment, the reasonable judgment. But I'll come on to that in a moment, and that does relate to the Tesco.
That's a different point to
Yes.
the test, which, as I say,
Yes.
I'm not sure there's very much between you.
Now, just a very short point. My learned friend has sought to cast the judge's decision as some sort of horrendous anomaly. The only textbook which we've found which deals with the decision is in the authorities at page 799 in tab 33. I'm not even going to suggest we look at it, but because I only have one point on it, which is basically, it doesn't exactly say we can't for the life of us see how the judge can have come to this decision. There's no suggestion at all that there might be something wrong with it.
Worried it might be scrutton on charter parties for a moment.
What it does say is the court confirming Letesco reached this decision, which I
Makes
don't,
sense.
neither of you, I think, well, maybe you will support that.
So, I hesitate to go back to the Triton Lark, but and perhaps we don't need to go back. But there's an important paragraph, paragraph 55. The judge deals with something separate to what we were talking to the construction issues that we were considering before, because he considers there what a reasonable judgment meant in the Triton Lark charter party. It might be worth turning this up actually, because it was so that this is page 260 of the authorities bundle. This was discussed this morning to some extent. So it's in paragraph 55. One can see in paragraph 54 that Mr. Nolan has submitted that there needs to be an implied term in line with the Socoma line of cases and the product star. So this is the point here is that is as to what extent this is it in any way a discretion. And in paragraph 55, he says there is no necessity to imply any term as to how that discretion or power must be exercised, because the clause said expressly that the owner's judgment must be reasonable. The effect of that clause is that the owners must make a judgment. It must be made in good faith, otherwise it would not be a judgment, but a device to obtain financial gain. The judgment must be objectively reasonable. And then he talks about circumstances in which an owner might be able to rely on his judgment even if he doesn't make all necessary inquiries.
Yes, I mean, the word necessary there, I think, can mean no more than those necessary for the resultant conclusion to be fairly described as reasonable. But you can always come up with
Yes.
something else someone could have asked.
the purpose of going there is just to make it clear that what we're not dealing with a discretion clause in the same way as you might be dealing with such a clause if it was, let's say, the owners don't have to go to Suez, or the charterers can ask the owners to go to Suez, and their consent is not to be unreasonably withheld. So there, you'd have a clause where the owner takes into consideration matters of their own convenience, matters of the charterer's convenience. We're not dealing with that kind of clause. In our case, however you construe exposed to sanctions, it's requiring a state of affairs, a judgment as to the existence of a state of affairs.
It's what one commentator has described as a determination discretion.
Yes, that sounds like a very fair description of it. But that also, and Mr. Justice Tear's use of objectively reasonable here, goes to the way that the type of judgment that will count as being a reasonable judgment. Now, could we go to paragraph 80 of the judgment in this case, the judge's judgment, and that is page 81 of the core.
Yeah.
And this is an important part of the judge's decision. Paragraph 80. If the judgment is based on speculation, it will not be an objectively reasonable judgment. Now, he cites Foxton, J, in Litasco, it's true, but...
Which was a case which did not involve anyone making a judgment, apart from me, I think.
Well, yes, that might be true, but in fact, there's a neat link to what Mr. Justice Tear has said in the context of a reasonable judgment clause there. It needs to be an objectively reasonable judgment and not based on speculation.
I don't understand that. I'm afraid I simply don't understand that. We have to assume for this purpose that you're wrong in your construction. So the owner has to come to a reasonable judgment about risk. That's risk of something happening in the future. That must be speculation.
Yes. What the judge is saying here in one sentence is that as part of his decision, he is going to have to separate what is known, what the owners know, what they know to be the case, what they know not to be the case, and then he's going to have to look at what's in between that and make a judicial determination as to whether the things that they're not sure about, they're sure enough about. Is there enough evidence of them to permit them to infer certain things? And so his use of the word speculate there is captures the fact that there will be matters where his determination is that owners are impermissibly speculating. Because the one thing which must surely be right, that the clause is not saying that if you reasonably determine that certain facts exist and that performance leading to a breach of sanctions is a possibility, is not ruled out on the facts that you know, that can't be enough. So, and if that's not enough, then the judge has to make a judicial determination as to what is speculative and what is sufficiently
He just has to
known.
reach a view as to whether it's a reasonable judgment.
I mean, you can say that there may be some risks that are so improbable that they're not real risks. I can understand that.
Yeah.
The level of risk may fall below one of sufficient seriousness to trigger the clause. The judge adopted a real risk and
Yes.
was excluding fanciful. So I can see that if the risk you identify reasonably is a fanciful one, as it were, then you're in trouble.
Yes, and that involves the judge in weighing up all the evidence, weighing up what the owners knew or should reasonably have known, and making a decision on where that took them or where that should have taken them, and whether it hadn't taken them far enough, and that they were having to simply speculate to bridge the gap between what they knew and there being a real risk of sanctions.
But
Now-
this is about process, isn't it? To say the judgment is based on the judgment actually reached by the owners was based on speculation, is to say something about the process by which they reached their judgment, isn't it? And I thought you were saying that Mr. Justice Tier in the Triton Lark was correct to say that it's not about process; it's about whether the outcome is reasonable, objectively.
On what they knew or could reasonably have known, whether the gap between that and a real risk of sanctions was speculation. Not necessarily that, so detach it from what they actually knew, having done what they did. The question is whether on what they knew or ought to have known, on that information, what the information you could know, whether the gap between that and a situation of a real risk of sanctions was speculation, was speculative. So that's why we draw a parallel with Matasco, because in that case, and this is quite apart from the context in which the decision was made, the decision on the evidence is that to go from this man once owned and controlled this company to he currently owns or controls this company, even following an apparent divestment of his interests, that is pure speculation. That's just a conclusion. That's just a forensic point or a point on the evidence. And so the parallel with our case is that here the judge says, well, this is what the owners know or ought to have known, but to get from there to there being a real risk of sanctions is speculative, because we know that he once had this association with Neftisa. He's apparently divested himself of that interest, and that's all we know. And so the gap between that and there's a real risk of you owners being sanctioned is filled only by speculation.
I'm trying to work out where would it fit into this analysis if owners said there's a real risk he still owns the company? Is that speculation, or is that the determination of the objective real risk that satisfies the clause?
That's pure speculation, as it was in Matasco, simply as a matter of the evidence. It's in Vinesh Prombank, the judge, who comes to a different conclusion to the judge in our case, on a different question, admittedly. But one of the points that Mrs. Justice Cockrell makes is that you've got a divestment, but what next? But that doesn't tell you. The divestment, all that tells you is that they have reduced the association they had with the company. And then you have to ask, well, what do we know? What else do we know? What happened after that? What do we know that can which can reanimate their control or ownership? And the judge in this case said, we don't know anything. And therefore it's speculation. And the point of taking your lordships to paragraph 80 is that he was saying it won't be objectively reasonable to say that there's this real risk if you're bridging the gap between what you know and don't know to that real risk with speculation. Now, the other point about 80 and 81 here is that they are not part of the appeal.
The trouble with that is it all depends. It all depends. You keep talking about a gap, but there may be overwhelming evidence which may lead to a small gap which you're entitled reasonably to jump over. Now, I appreciate you say that's not this case. I understand that. But in my view, speculation is inevitable. The question is whether, to the extent that the judgment involves speculation, it was reasonable. And I would be very much against hemming in any ruling about how a reasonable judgment should be approached by inventing sort of rules. And to me, saying that a judgment based on speculation without more is a rule that at the moment I don't see any support for.
There are an infinite number of different fact patterns.
Exactly.
That's true. And the judge, in any of these cases, would need to decide whether enough is known and enough is known with enough certainty to say that there is a real risk, or to make a decision that actually there remains a gap, not just between what's known and confirmed unlawfulness, but between what's known and it being able to say objectively on evidence that there is a real risk. Now, so that's the point. These decisions are going to be highly fact sensitive, yeah. And there are an infinite number of different fact patterns. The judge needs to weigh the evidence, and I'm not saying that there needs to be some sort of unspoken rule which applies to all cases in this context. But I do say that that paragraphs 80 and 81 are not challenged, and even in the process of obtaining permission to appeal, they were endorsed. So that's, it goes to 2 points. One, is it really fair to start saying that there's no, that even speculation is fair game? But the other point is that it's even less fair on the judge to say that if he decided that there was a speculation gap between what the owners could reasonably have known, or knew or could reasonably have known, and a real risk, to say that the judge was wrong to think that was a problem. I mean, he wasn't.
Well, he doesn't talk about a speculation gap. The basis for his rulings are at paragraph 132. The 4 subparagraphs of 132. So that's the key bit. He doesn't talk about speculation or a gap. He just says they didn't know in relation to the control of the company.
Well, in 1322, he says whether he did control Neftisa or not is speculation, and then at the end of that paragraph refers to the Tasco and says the case falls squarely within the speculative category. And then in 1324 says, I do not agree with the claimant's analysis. In my judgment, there was therefore no evidence as opposed to speculation for the defendant to rebut.
Yeah. So you say speculation is a key part of that finding?
I'm saying that on a fair
No,
reading...
answer my question. Do you say that the speculation and the fact that the judge considered or concluded that the appellants had to speculate beyond which was reasonable in order to come to their judgment, and therefore they failed, as he found? Do you say that's based, or one of the key planks of that is that they speculated.
Yes.
Yes. So therefore 80 is in play. It must be, because that paragraph in 132 is at the heart of the appellant's appeal. So if, as you say, that is based on the judge's conclusion as to speculation, that has its foundation at paragraph 80. And therefore we'll need to look, I think, at this paragraph, which I'm sure my Lord is familiar with, but I'm not, about speculation in Litasco.
Yes, well,
64.
yes, I mean, the point I made about being fair to the judge was that I mean, as is reflected in the fact that it wasn't challenged in seeking permission, there's no quarrel with the idea that speculation, that there's a meaningful distinction between evidential basis and speculation.
I mean, I'm just wondering whether we're over-atomizing all this. I mean, doesn't it come down to the fact either on the material available to them, a reasonable owner could conclude there was a real risk, or if all a reasonable owner could conclude on the basis of that material was, you know, really a fanciful risk that does not deserve the epithet real, then on the judge's view, that's not enough. And you're going to look at what's known to them and what can be reasonably inferred as a realistic possibility from what's known, and it'll either be good enough or it won't.
Well, there's another stage, which is, was the judge entitled to reach the conclusion that he reached?
We've done that. We're muddling together two things, and I did try and distinguish them about 20 minutes ago. One is what the owners were entitled to do at the time and the reasonable judgment point. The other is what the judge was entitled to do and you would say, the stringency of the test before we intervened. But they're entirely different things as a matter of law and procedure, and different considerations apply. So we need to be careful as to which ones we're addressing. I'd understood you to be addressing the test that the owners were seeking to fulfill, namely the reasonable judgment.
Yes, that's right. I wanted to make sure that there could be a danger of approaching this simply as a sort of bypassing the judge and saying, what do we? That's one of the dangers if you're going to go into lots of the primary evidence. There's a danger of bypassing the judge and saying, what would we have decided, which is not quite the right way to approach it. That's the only point I wanted.
I can assure you, Mr. Shirley, that after 8.5 years in this court, that is the first and last thing I always think about. The trial in front of the judge was not a dress rehearsal. It was the first and last night of the show.
Thank you.
Not my words, sadly, but as you know, Lord Justice Lewison.
The other one we came across is the judge had the whole sea of evidence in front of him that the Court of Appeal is just island hopping.
I think it's in the same judgment, isn't it? Phage.
I always say if he could charge royalties on citations of those two passages,
Exactly.
he would not need the judicial permission.
Litasco, paragraph 64.
A modest little paragraph, some might say.
Yes. Dealing with the question
Of the evidence.
on the evidence in that case, is it arguable that Litasco is controlled by Mr. Alekperov?
Yes, that's right. But it's hard to criticise the judge in my submission for drawing a parallel here, because you've got a founder, at one stage, an important figure at Litasco, who responds to sanctions by divesting himself of his interest. And then there is the speculation that perhaps there's more to this than meets the eye, which, in my respectful submission, Mr. Justice Foxton, as he then was, said that's pure speculation. And the question is, as it was in our case, right? You've had the divestment. Where next? What else do we know? What do we know to contradict?
His brother's got it, you know.
But then that's met by the response that his brother is an independent businessman. So he's not just.
I'm answering your question. I know it was a rhetorical one, but you've asked it 3 times now, so I'm answering you. His brother got it. His brother had those interests. Did Mr. Alex Perov, did he give it to his brother?
He didn't sell his shareholding, I don't think. He only ever had 8 points. He stood down as a director from a board of a company that operates, one remove, refineries in this country without anyone suggesting that it's all sanctioned.
Well, I mean, Neftisa is still not designated on any of the lists, which, and that's despite the brother now being designated. This whole thing about the brother, and we're slightly skipping ahead here, but it's unreal in my submission to say that there's something obviously untoward about him passing the company to his brother, because it's unreal to think that these 2 serious businessmen would think, right, what we're going to do, no one will notice, don't worry. We're going to allow it to be well known, to become well known, that I've responded to sanctions by transferring the company to you. Don't worry, no one will ask any questions about that. The much more credible conclusion, quite apart from whether the judge was entitled to reach his conclusion, the much more credible conclusion is that this was the type of divestment that you see a parallel with in the Deripaska case, where he steps back in various respects so that the company can operate. That the Infraspectrum report says appears to have been the case with Rosneft, that the divestment's likely to have been so that the company can trade freely, unburdened by its association with a sanctioned individual. So it's one of those, you say to someone, well, you know, he transferred the company to his brother. And some people will raise an eyebrow. But actually, the far more absurd suggestion is that there was something untoward going on, because Mr. Gutseriev could have found anyone, surely, any nominee, if he wanted to do something dodgy. I mean, it seems to me an absurd reading of what's happened.
I mean, we don't know the value of the stake transfer, but it would have been worth a very significant amount of money, wouldn't it?
That's right. But there's no reason why we ought to know any of this. I mean, that's the difficulty in saying, well, we don't know this, but there's no reason why we ought to know. So it can't be used as a basis for saying something untoward was going on. But we are not in a position to get any of these people.
We would be speculating, I suppose.
We would be. I mean, in Vinesh Pombang, there were multiple overlapping factors which led the judge to say, well, I would have concluded that there was reasonable cause to suspect. We don't have them in our case. What we have is indications that, and in fact, in Vinesh Pombang, the judge gives an example of a divestment that might not be suspicious. And that example, it's not to a family member, but it's to an independent businessman who might have an interest in operating the company himself. So not a nominee who's never run companies before or anything of that kind. That what the appellants put forward as being the sort of smoking gun is absolutely the opposite.
Okay, we have that. Is there anything else we need to look at in Litasco, or can we put that away?
We can put Litasco away.
Thank you very much. So where do we go next?
Well, Vinesh Pombank, I'll see how much we really need, because we have already looked at it today. Paragraph 84 in Vinesh Pombank. I mean, it's sort of up to your lordships whether you want to turn it up. I can tell you the point that I want to make. I mean, if we have it open, then we've got the option. It's the next authority. It's tab 23, and paragraph 84 is on page 568.
Paragraph 84. Yeah.
Yes, and you can see that the judge is asking a different question, is answering a different question, but you can see the approach taken in a divestment situation here, entirely consistent with Litasco. The judge is looking for still such indications that the ownership and control provisions apply. So the question is not whether there was this divestment, which there was, like in our case, but whether we have anything post divestment to suggest this was anything other than an ordinary divestment that relinquishes control and that replaces it with this alleged de facto control. And as the judge decided, we don't have it in our case. All we have is speculation. I mean, I say he was clearly right about that, but even if he wasn't clearly right, it was a decision that was open to him. That's 84, the need for further indications. 98, which is on page 570, there's another indication of what might not be enough, where the judge says, there are some grounds for scepticism, but short of the level required for the purposes of the test that she's applying. And it's in the next paragraph that she gives the example that I mentioned a moment ago. Is there material which goes to cast doubt on the picture? For example, to portray Mr. Fane as a business operator who would wish to own and operate A1 himself, which is what we have in our case. Transfer is not just to some nominee. If you're in Vinesh Pombank, we've got a similar-ish situation, but a completely different type of transferee. So, I mean, we've been to the multiple overlapping indications. On the way, the judge dismisses, this is in paragraph 105 to 106, the judge dismisses press reports which have been relied on. So it fits in with the theme of speculation just not being good enough in this kind of situation. But stepping back, what we get from Litasco and Vinesh Pombank is different judges weighing different pieces of evidence and evaluating what was known about control in different situations. Essentially what the judge did in this case, taking into consideration the evidence that he looked at, but also the countervailing evidence. Now, I'm going to, I think it's unavoidable, go through the that evidence and make my
yeah. That was the third of your three subheadings under this. So,
but just a word.
I've been waiting for it.
A word about his test, because we say that if one looks at paragraph 131 and 132, it's very unfair on the judge to suggest that he's decided what the test is and accepted the claimant's case on that, and then gone off and applied a different test. I mean, immediately above paragraph 131, this is on page 92 of the core book. He says, whether the claimant made an objectively reasonable judgment that there was an exposure to sanctions in that the listed persons were subject to the risks of sanctions or open to the danger of sanctions. And in 131, he says, having considered carefully all evidence the parties' submissions on it, I have reached the conclusion that the claimant has not satisfied the provisions of Subclause C and did not make a reasonable objective decision that listed persons were subject to the risks of sanctions or open to the danger of sanctions. Now, so how can it be said that he has not applied the test? I mean, he's telling us he has applied the test. Now, it is said that in 1322, where he says, at the bottom, where he says, it's insufficient to amount to an objectively reasonable decision that Mr. Gutseriev had de facto control and therefore entitled the claimant to rely on the provisions of Subclause C. That is entirely consistent. It's not inconsistent with his application of the test. He's not saying that that is the only way that the test could have been satisfied. If the owners had made an objectively reasonable decision that Mr. Gutseriev had de facto control, then on the judge's test, they would have been entitled to rely. And reading his judgment fairly in my submission, including him saying expressly that he is applying his test, and saying, I have come to that conclusion for the following reasons. Those reasons are all relevant to that test. They don't, on a fair reading, suggest that he's gone and applied a different test and required a different standard to be met. Because, as I said, there was a common position that he had a decision to make between evidence and speculation, and that's what he goes on to do in that paragraph 132. He's clearly determining whether we know anything, or whether the owners could reasonably have known or did know anything about continuing control or de facto control that was not speculative.
Let me explore that a minute, because if all the facts known are, in face of sanctions, the owner of the company, the sanctioned owner, or the listed owner, transfers the entirety of his interest in the company to his family member. Nothing is known as to whether anything was paid for that. The timing gives rise to a suspicion. It may not be a red flag, you'd say, but it's some sort of suspicion. The only question is on the test and the regulations is whether, notwithstanding that transfer, behind the scenes, pursuant to some private arrangement, the brother is willing to do what his original owner wants. Now, no one other than those two people can know that. That's a private arrangement. But if it exists, there is the relevant control. If it doesn't, there's not. What more could anyone ever hope to achieve or obtain in terms of trying to answer that question?
Well, for there to be a conceivable risk of sanction, for there to be sanctions, the authorities would have to conclude that Mr. Gutseriev was in control of Naftisa. We saw from Vineshprom Bank that that is a threshold requirement. So, if what one knows is only enough, essentially to say, well, we can't exclude the possibility that they have a private arrangement that no one knows about, then there's no conceivable risk of sanction because the authorities can't, on that basis, conceivably conclude that Gutseriev is in control. And
can't they? I mean, it's a judgment call, isn't it? Looking at the inferences to draw from the circumstances, and they can ask the question: what money was transferred for this? If there's no answer to that, or there was no money transfer and no consideration for the shares, then they could reach a fairly quick conclusion, couldn't they?
Well, in my submission, one can't get home by speculating the existence of facts and then speculating that the authorities might learn of those facts.
But these are all facts within the peculiar knowledge of, in this case, the respondents.
Well, not the respondents, I don't think.
You're probably better placed than the owners because they are contracting party, but the
I mean,
shippers are
you would know what he paid, if any, what the brother had paid, if anything, for this very valuable company, or control of this very valuable company.
I'm not sure why we would know. We may have brought Naftisa into the picture, but we were reliant on them to provide documents to the extent that nobody or anybody was able to find out things by looking at the public sources. So there's no reason that we would have known that. But also it's not, in my submission, fair to say that no one could ever know about an arrangement which would cast doubt on the genuineness of the divestment. But perhaps it's easier to say that in this case because owners did not in fact have any evidence of that. But there could have been...
Well, as my lord had said, only the brothers would know that.
Well,
at the time of this decision, only the brothers would know that.
Well, I'm not sure that's right because we are in November 2021. We are now a number of months after the divestment and the sanctioning, and yet what we don't have is increasing press reporting of Mr. Gutseriev having an ongoing connection with Naftisa. We don't have anything. We don't have that. If that private arrangement existed, which, as I've said, is, when you think about it, extremely improbable. But
well, you're speculating again. Your submission is there's no press, so that's an indication.
Well, there's no nothing. There's no.
Well, there's a Court of Justice decision, isn't there?
Not in November 2021.
No, but you said in the time since then. I understand you're saying where's the press? Or do you mean between July and November?
I meant just between the divestment and sanctions and the decision in November 2021. I meant just in that period. So there's a divestment, and then apparently no evidence that is anything other than it claimed to be. And there's evidence that to make you think that it was what it claimed to be, because there was this competing theory which, as I said, seems much more likely to us that the divestment had been to preserve Neftisa's ability to trade.
So what do you say? There's a competing theory. What evidence is that based on?
One of the documents that was available to the owners was the Infospectrum report, which we saw this morning, where they say essentially it's likely that Neftisa will, or Rosneft, because the report's about Rosneft, it's likely that Rosneft will be able to continue trading, and it suggests that the reason for Gutseriev stepping back from Neftisa, or Rosneft, was to permit Rosneft to trade in the manner that it was accustomed to.
Well, so that it could carry on. Either A, because in fact he's really divested, and so, well, B, it's made it look as if he has. It's neutral, that, isn't it?
Well, no, in my submission, not, because it's not going to be able to carry on trading in the manner it's accustomed to if all he's done is said, "Oh, why don't I give it to my brother? But I'll really stay in control of it." I mean, this is a man who appears to know his way around the business world. That seems a highly improbable way to characterise the facts, that he's thought, well...
But again, you're speculating. Cosmetic divestment is what all of these cases are about. You say it's highly improbable, but businessmen exposed to sanctions, that's what they've been doing.
Well, on the facts of this case, I'm saying that it was highly improbable, and that the document which Mr. Tay said in cross-examination he'd like to have seen at the time, because it would have helped him to conclude that there was nothing to be worried about, was a document that gave this competing motivation for stepping back from Neftisa, which is, where if I stay involved with Neftisa, it's not going to be, Neftisa won't be able to trade. But by making by there being a genuine divestment of the company, it can continue trading.
Yeah.
I mean,
so that, as my lord said, there's two entirely plausible answers. It's either a cosmetic divestment or a real divestment. And we can't say, and we can't speculate.
At the end of the day, the judge took into account that alternative explanation.
Where's that?
In the judgment, I'll have to... Yes, it's in 1323, at the bottom of 1323. He says, the rationale for his stepping down from the board of the company was set out in page 5 of the Infospectrum report, namely, widely reported as having stepped down with the likely intention of giving the company the freedom to manoeuvre in the manner to which it is accustomed.
But that's a quote from the report.
Yes, from the report. Which I mean, the judge in my submission...
But that doesn't answer the question. They want the freedom of manoeuvre to carry on as they have been. That doesn't answer the question as to whether it's a cosmetic divestment or a real divestment.
But in my submission, it's far more consistent with the idea that it was a genuine divestment, like the Deripaska divestment reported in the Navigator Equities case. Because obviously there are different ways of reacting to being sanctioned in this situation. You can try to do something that is dodgy, or you can say, well, I'm sanctioned now. This company is going to have trouble trading if I don't genuinely divest myself of the company. And it's speculative to say, to suggest that actually what's gone on here, and inherently less likely that what's gone on here is that these two very successful businessmen have said, well, why don't we just make a highly publicised divestment from me to you, I'll carry on controlling the company, and don't worry, I'm sure we'll get away with it. It seems absurd.
Well, I mean, the history of large commercial transactions in the former CIS states are replete with examples of very major industries being held by nominees on behalf of others, and the litigation in this courts have benefited very greatly from that over the years. I'm not sure it's quite as shocking a proposition as you suggest. It may not be right, but at least as a possible realistic scenario, it doesn't strike me as otherworldly.
At the very least, it was. I mean, we're not dealing with a classic nominee here. We're dealing with an independent businessman who had, you would have thought, an interest in running the company himself, and no interest in being involved just as someone's nominee. But also,
how do we know any of that? We just know he's his brother and he's a businessman.
yes, but
You're filling in an awful lot of gaps in support of a case that starts on the premise that you don't have any speculation.
What I'm trying to do is to be fair to the judge, who weighed up all of these things. The judge was told multiple times that he couldn't possibly, by the appellants at trial, that he couldn't possibly come to the conclusion that it wasn't reasonable to judge that there was a real risk. And all the stuff about the brother was put to him a number of times. The judge weighed up everything, including the alternative rationale from the introspection report, including the fact that the brother was an independent businessman, and concluded that actually they couldn't take it any further than the divestment, just as the party in the Tasco couldn't take it any further than the divestment in that case.
Can you just help me? Where do we find the evidence as to the nature of the brother's independent business? What do we know?
Probably the best thing to look at is in.
Is fine.
Sorry?
References.
Oh yes. So we're going to So supplemental bundle tab 8.5.
So is this in the judgment?
No, this is in.
Is there any reference in 132 to the brother?
I'm not sure there is. Well, there's a reference to the Commerçant newspaper article, but.
So there's no reference to the divestment to the brother.
I would have to do a word search.
1252, in relation to the legal opinions, recites what they say, which is that
But
he was a
nothing
wealthy businessman.
But in the discussion and conclusion on this point, which as we know is 131 and 132, there's no reference to this point.
Yes, but in my submission, it would be very unfair to the judge to suggest that he had overlooked the fact when reaching his conclusion that the divestment was to the brother.
But that's just an assumption that Baker and Mackenzie were asked to make. Where's the evidence?
Well, that on. I'll just turn it up in my bundle. Yes, no, my reading, I believe, I'd have to look for it, but I think perhaps the judge also picked up on this. But my reading of the report was that among all of the...
Page reference, please.
Oh, sorry, 137 in the supplemental bundle.
So this is the Baker-Mackenzie memo.
Yes, on EU sanctions.
which we looked at other part. We looked at the executive summary. So which of 137?
So 137, the very top. Is that, in fact, it starts the sentence starts at the bottom of 136.
You're right. There's a Wikipedia reference to him being a Russian oligarch and businessman.
Yes. So among all of the stuff which is assumed, or they say we're advising on this basis, this was one thing which I read as being them applying their minds to the situation rather than just making an assumption.
Certainly, they did some research of their own to the extent here set out. Thank you.
We can check if that point
I
is...
think you're right on the basis of that.
So, I have a few things to say about the various pieces of evidence. We've probably dealt with...
I'm sorry, just before we go on from that, you will read the first sentence of that paragraph I have.
Which paragraph?
The one at the bottom of page 136. Younger brother has been
Yes,
in business part
yeah, I've read that, the whole of
their first business enterprise.
Yeah. Yeah. Sorry, Mr. Shirley, you were saying in relation to the material.
Yes. So, owner's case that they put to the judge was based on de facto control. So, that involves the proposition that the authorities might conclude that, might reach a conclusion on Regulation 7.4 that Mr. Gutseriev was manifestly calling the shots at Neftisa. And we say it was speculation that he was manifestly calling the shots. Now, the Refinitiv World Check reports, I mean, I detect from this morning's submissions that not a huge amount of weight is now placed on them. One point I wanted to make about those was that they are caveated in much the same way as the legal opinions are caveated. So I've got a reference for that, which is page 159 in the supplemental bundle, tab 8.8.
Yes, I mean, for my part, I didn't think the language about third parties can't rely really moves the dial. And we all know that experts put that on. Indeed, I've had experts' reports numerous times before me in court where they say no one can rely on it. So I thought, well, I hope I don't fall within that group.
So this, are you 159?
Yes.
The small print, the contents of this record are private and confidential and shouldn't be disclosed to third parties. Is that the bit you're... Is that the bit you're relying on?
Let me just... Yes, well, you shall not rely upon the content of this report without making independent checks.
Yeah.
Well, we said you don't see anything that goes anywhere near establishing a risk of de facto control from the Refinitiv report. One reason is that the caveat, the other is that they don't say anything that could persuade you. What they record is the divestment. they're evidence of the stepping back. They're not evidence of anything that happened after.
Yeah.
Now, so I think that we've looked at the information that owners had that didn't come from us. Then we've got the Neftisa letter. We've heard something about that this morning. This is the one that's at page 178 of the supplemental bundle. Now, in my learned friend Skeleton, at paragraph 21, he says that these materials supplied by the charterers seem to have weighed heavily with the judge. But the judge was clear that, in fact, he didn't think we even got into these or needed to get into this material, because the other material relied on by the owners didn't establish the prima facie case. So it can't properly be said that this material weighed heavily on the judge. But nevertheless, it was there and it was provided to the owners. And just one overarching point about the material. It may have been based to an extent on assumptions and believing that documents provided to the writers were genuine. But first of all, it is evidence of what documents that we have no reason to think were anything other than genuine said, as interpreted by the law firms. So they had been provided with documents. What their opinions, the facts assumed in them, reflect what those documents showed them. And although the law firms assume the correctness of lots of the facts in their opinions, even now, we're not able to say that any of those facts are not true. As far as we know, the facts that they have assumed are the facts, and therefore the conclusion that the law firms reached based on the facts assumed in their opinions are the correct conclusions to reach. And owners didn't have anything else to provide them with a non-speculative basis for saying, well, actually, there's more to this than meets the eye. Didn't have anything. Now, the Neftisa letter, I'm not sure how far this is pursued, because we didn't really hear about it this morning, but it can't be right for the appellants to say, well, where's this document? Why haven't you got an affidavit from the Gutseriev saying they don't have control anymore? Why do you have any sort of statement? Why can't you give us official documents? On the other hand, say anything we do produce is in some way suspicious and probably just cooked up at the behest of Mr. Gutseriev. They can't have it both ways. And the truth is, we don't have any reason to suspect that the Neftisa letter isn't a genuine letter from a company that is not designated.
Well, how far does it go, the letter?
Well, the Neftisa letter addresses the position under Russian law, but it's fair to say, as was identified this morning, that the matters it addresses are pertinent to the issues that owners were considering. So we don't, in my submission, need to put any particular weight on any of these things that we provided them with, but they did all speak with one voice. They may have been based on assumptions, but assumptions as to facts that we still have no reason to think are not true.
Who is the sole shareholder of the joint stock company?
Dolmer, I think it's Dolmer Enterprises, perhaps. We've got the organogram in.
Oh, right. So that's a company. That's a company entity.
Yes, that's right.
So, because we're informing you that on the basis of the information provided by a company,
Yes.
blah blah blah.
Who's the shareholder of that?
Well, it's probably worth you having a reference to the organograms. They are so supplemental bundle 199, which confusingly, well, in mine at least, which I think it must be the case for everyone, has the 199 on the spine.
Yeah.
So you won't see it at the bottom of the page. But 199.
Is this the same as the other chart that we saw?
They're not identical.
In terms of, oh, they're not.
I haven't spotted a difference in terms of the information, but they're not identical. So the other one is at 141 of the same bundle. But both show Dolmer Enterprises as the shareholder of the TISA.
But it's Mr. Gutierrez 1 or 2 that is the ultimate owner then of most of the shares. There's a 25% shareholding by
the brother is
previous
the man at the top.
Yes, as of that date. But presumably it was the other brother before June.
In fact, we don't have that. What we do have on 198, if one turns back over the page, is a schedule of the underlying documents that were not. We can't actually look at them, but there's a record of the documents that were provided to the law firm, and they detected no reason to think that those documents were not genuine documents, because that they surely would have said.
I mean, it's really only the third, isn't it? The first is the original founding charter, which would be a matter of public record and long predates any of these events, and the second predates the sanctioning. So it's really document 3. One suspects that is the key.
Yeah. Yes. So we don't have that, but we're talking about Herbert Smith Freehills, who say that they've seen these documents and provided they're genuine, and we have no reason to think they're not. Then the facts and legal analysis set out in their opinion is correct. It's not like the judge says, well, I assume all of this is true. He says, actually, I don't need to rely on this evidence that came from the charters, but it's quite proper for him to note that it speaks with one voice. And the legal opinions are hearsay evidence of the contents of the documents that they were provided.
Any other material you want us to look at?
Well, I mean, I'm conscious I haven't gone individually to the legal opinions, but we looked at them this morning,
and your submission about them is, you say, as far as they know, to the extent that they identify facts, those remain the facts.
Yes.
We have that submission.
Yes, and they were.
And you
based
say no
on
one has suggested to the contrary.
No, and based on primary documents that were identified. They certainly didn't give any reason to believe that there was more to this transaction than met the eye. So my final point on this is about the missing information. Now, I accept that I'm not saying that there's I'm not saying that there's some procedure breach by not obtaining this information, but it is striking that the owners didn't obtain a report designed to address the specific circumstances they found themselves in. They appear to have relied on very little in terms of, I mean, the approach they took essentially was to say, you prove it to us that this clause doesn't apply, rather than we can make the judgment it requires us to make that it does apply. As was candidly accepted this morning, there's no evidence that they even followed the links in the Refinitiv report, which were, I mean, one of the main purposes of the Refinitiv report surely was to say, here's a sort of headline summary you're not allowed to rely on, but for your further investigations, here are a whole series of websites that you can have a look at to follow up what we're saying here. Mr. Tay, in his evidence, as the judge records at paragraph 116 of his judgment, couldn't even say whether Google searches were done. And they don't seem to have had the reports on Neftisa or Mr. Gatsario that in his own witness statement, Mr. Tay said, paragraph 13 of his witness statement, which is page 81 of the supplemental bundle, he had identified those as steps that owners would typically take in this kind of case. So the judge had to weigh up this complex suite of different pieces of evidence. And we don't even have all of the evidence that he had in front of him. He had 3,600 pages or so. Not all on this, but that was the trial one. And he had to consider the various points that I've made, and which I made to him, and points that the appellants made to him at first instance, and weigh it all up and come to a conclusion. And for the reasons I've given, that conclusion was, we say, the right one. But even if you don't agree it's the right one, it must have been open to him on the material that he had before him. Because there was plenty of reason to think that this transaction was exactly what it said it was, what it was on its face. There was nothing generated between the divestment and the November 2021, which cast doubt on that scenario.
Yeah.
So owners basically recognise that it would have been a leap for them to conclude that Mr. Gatsario had control of Neftisa. But equally, it would be a huge leap for them to think that, based on the evidence they have, or had, should have had, that a sanctions authority might conclude, the sanctions authority can't just say, well, we think there's a risk. Sanctions authority has to conclude that Mr. Gatsario is in control of Neftisa. So looking ahead, the owners have to think, based on what we can see, there's a real risk that the sanctions authority will conclude, And it's absolutely clear they didn't have the information, and without speculation, they couldn't bridge the gap between what they knew and what they would have to have known to think that there was a real risk. What they had was just speculation. It wasn't evidence. It wasn't a proper evidential basis for an objective, reasonable judgment of the kind, even on the judge's test, that they had to make. So
I think that deals with the material. So does that leave the question of the European judgment?
Well, yes, I mean, I should just check the owner's grounds. I mean, we will essentially have covered them.
Well, why don't you do that overnight, and if there is anything else, otherwise it's the European judgment point, which is obviously separate, which you'll address tomorrow.
Yeah.
But if there is anything that slipped through the net, then you can identify that and address that in the morning. All right, and then we'll have, and then we'll hear you on the, I think, separate point about the European judgment. Okay, so 10:30 tomorrow. Thank you very much.
2Rivers Pte Ltd.